Court, you've now heard the first round of both parties in this case, and the witnesses and the expert. In these submissions, which introduce the second round of the Gambia's oral arguments, I'm going to address some of the bigger picture issues that are in dispute. I'll focus on the Genocide Convention and the role of this court as the principal judicial organ of the United Nations. First, the Gambia maintains the totality of its arguments. Nothing we have heard from Myanmar causes any change in our position. Quite the contrary. It is clear that Myanmar offers no real challenge to the essential facts, namely that huge numbers of Rohingya have been subjected to the most terrible atrocities: killings, rapes, brutalization, beatings, destruction of homes and villages, destitution, being driven from their lands and across the border into Bangladesh. Those of us in this great hall who attended the hearings in the Bosnia and Croatia case are bound to recognize that the nature and scale of the acts in this case are notably different. The fact of wrongdoing and the criminality on an industrial scale is not in issue. What is in issue is the characterization of those facts in law. Second, against the background of such terrible facts, Myanmar's options for argument are limited. We all heard Mr. Hooper acknowledge to witness MS that atrocities have been committed. Myanmar's strategy is therefore plain for everyone to see. 1. Challenge the probative value of the body of evidence before you, the manner of its collection, form, reliability, and 2, argue for an unattainably high bar for proof of intent to destroy the group in whole or in part. And as predicted, the approach of Myanmar truly was Dickensian, attacking the Gambia's arguments with 1,000 cuts, salami slicing away, taking you deep, deep, deep into minutiae in the hope that those who are listening will no longer be able to see the wood from the trees. It is indeed bleak house. Did you not at times feel, as we were taken village by village by village, that you were being ground to bits in a slow mill and then roasted at a slow fire? Not once, not twice, but 3 times and more. For no more than grains and drops of dispute, they argued. And as I listened to their counsel, it struck me as striking how they failed to address the bigger picture. There was no attempt to explain the pattern of conduct in relation to the crimes. No attempt to explain why villages were bulldozed after they were burned to the ground. No attempt to tell you why fleeing children were shot dead. No attempt, literally nothing at all, silence, to respond to the expert reports, 2 of them, of a retired, decorated US Army Lieutenant Colonel who on the basis of those reports told you in the very plainest of terms that what you have before you is not ethnic cleansing or war crimes, and that Myanmar's conduct can only be explained as the expression of an intention to destroy a part of the Rohingya group. Professor Newton's testimony is completely unchallenged. Which brings me to a third point. Beyond the parties' arguments on law and fact, you've now heard from witnesses. You've had a chance to question them, to assess for yourselves their credibility and their reliability of the first-hand accounts of what befell them. And that evidence shows clearly that the particular circumstances of the village from which they came was genocide. Witness MS offered a harrowing account, one that included the murder of his wife, 5 of his 6 children, and 56 close relatives in the village of Mingi. His account of the facts was not challenged, and you saw for yourselves in this courtroom the continuing consequences, the serious mental harm caused to one member of the Rohingya group within the meaning of Article 2, Paragraph B of the Convention. Imagine his testimony repeated tens of thousands of times more. Witness NJ offered no less devastating an account. You heard from her directly of the deaths of her husband and her father-in-law, how one of her children was taken from her arms and murdered by being stabbed and then thrown into a fire before her very eyes. And you then heard how she was gang raped. You heard too from her of the discriminations to which she has been subjected. No freedom of movement, no education, a mass of restrictions and humiliations, no citizenship card, all imposed by the Myanmar authorities, and then confirmed and elaborated in response to the questions put by Judge Sepudinde. Cross-examination by counsel for Myanmar made no dent whatsoever. And witness MN's account was equally horrifying. You heard directly how this man, a teacher, was part of a large group of men, 87 in number, he said, separated from their families in the village of Mong Nau, taken to another place, and then executed. He was the only survivor. And for this reason, as I listened to his account, what came to my mind was another account of a mass killing, also told by a teacher, one that was written about 80 years ago. His name was Gershon Tafet, and he wrote of a massacre in a small town called Żółkiew, then in Poland, today in Ukraine. And like witness MN, Gershon Tafet was the only survivor of a genocidal act that took the lives of the uncle and many family members of a man whose portrait hangs in the judge's reading room in this court's new wing, Judge Hirsch-Lauterpacht. I mention this because that act of killing, evocative of what we have heard from witness MN, was precisely of the kind that inspired the drafting of the 1948 Convention on the Prevention and Punishment of Genocide. And contrary to what Counsel for Myanmar told you, there is a direct line that connects then and now, and that feeds into the role and responsibilities of this court today. After the witnesses, you heard from Professor Newton, an independent expert, that's not an issue, who has provided reports and an affidavit for the court and whose testimony is unchallenged. Under cross-examination by counsel for Myanmar, you'll have seen for yourself the care and diligence with which he carried out his tasks and the clarity and the authority of his conclusions. He made crystal clear, not least in response to some of your questions, that any suggestion that the atrocities described by the 3 witnesses and acknowledged by Mr. Hooper cannot possibly be explained as a mere excess in legitimate counterinsurgency exercise or an exercise in ethnic cleansing. The argument is a sham, he said, of the counterinsurgency claim, and he made very clear why. I can do no better than remind you of Professor Newton's words, and I quote, "I'll give you the modus operandi again," which is absolutely indicative of an intentional, coordinated series of attacks directed against that portion of the population, surprise attacks, no notice, no warning, often from multiple angles, indiscriminate shooting, no effort whatsoever to determine an ARSA location or an ARSA house or a safe house or an IED factory, no cordon and search operation, followed by segregations and executions, followed by mass extermination, the same pattern over and over and over. Extermination, shooting at refugees, mass rapes orchestrated, followed by the burnings and the bulldozings. Counterinsurgency? I don't think so. Ethnic cleansing? Try explaining that in your judgment. The witness and expert testimony you have heard is fully conclusive of the facts on pattern of conduct to which they attest. It is fully conclusive. And let's use the French language because it is slightly different. Ayant pleine force probante. These characterize what happened in the particular circumstances and what happened in scores of villages as genocide. These were not killings like Mailai or Haditha, one-off war crimes. Nor were they, as Professor Newton made crystal clear, ethnic cleansing, which is a crime against humanity. It is not ethnic cleansing, Professor Newton told you, because ethnic cleansing does not involve mass rapes with ethnic slurs, or babies killed and thrown into burning houses, wells and rivers, or the killing of the children of a particular group, or the slaughter of men, or shooting at fleeing refugees, or sinking boats. This is not just ethnic cleansing. Retired Lieutenant Colonel Newton of the US Army told you. It is fully conclusive of the existence of a pattern of conduct, one that gives rise to the only reasonable inference, conduct intended to destroy the Rohingya community in parts of northern Rakhine State. I turn to the Genocide Convention. First, a few general comments, and then some specific ones on burden and standard of proof. Contrary to what Counsel for Myanmar said, the genesis of the 1948 Convention is important, and it is relevant to the treaty's interpretation and application in this case. After Nuremberg, when the judgment failed to mention the word genocide, Raphael Lemkin almost single-handedly procured Resolution 96-1 at the UN General Assembly's first ever session. The resolution affirmed that genocide is a crime under international law, and the resolution requested the UN Economic and Social Council to draw up a convention. That convention was concluded in December 1948 in the session held at the Palais de Chaillot in Paris, just as Jean Cocteau's films Les Parents Terribles opened in the local cinemas. The UN General Assembly is the decent parent of the 1948 Convention. To be sure, the Convention does not include everything that Lemkin wanted, like the protection of social groups or culture. But to all intents and purposes, it is fully a reflection of the ideas he set forth in Chapter 9 of Axis Rule. And for the rest of his life, 11 years, Lemkin devoted himself to lobbying countries to ratify the Convention. And 3 years before he died, in relation to Myanmar, he succeeded. The writ of the Convention was limited until the mid-1990s, and then came the terrible events in the former Yugoslavia and Rwanda. The UN addressed those moments by creating 2 international criminal tribunals, and their work provided a jurisprudence upon which this court could rely in the Bosnia and Croatia cases. In this case, you do not have the jurisprudence of an ICTY to turn to, or any other judicial body that has gathered and tested the evidence. But do not say we have nothing to evoke the title of Madeleine Thiem's prize-winning novel. In fact, you have a great deal, and it is highly significant, and it is probative. For the UN General Assembly and related UN bodies have actively and effectively fulfilled their mandates in responding to the allegations of atrocities in Myanmar once they began to filter through. By Resolution 3422, on 24th of March 2017, the UN Human Rights Council responded by creating an independent international fact-finding mission, the FFM, to establish the facts and circumstances of what was going on, the horrors. The resolution was adopted by consensus. 3 individuals were appointed to the FFM, highly experienced lawyers, each of them, from Sri Lanka, from Australia, from Indonesia, led by the former Attorney General of that last mentioned country. They spent 15 months assisted by a highly professional team. They gathered evidence, including 875 witness testimonies, and they wrote a first 440-page report. Published on the 12th of September 2018, it concluded that the crimes in Rakhine State were perpetrated with genocidal intent, having regard to, and I quote, the jurisprudence of international tribunals regarding the reasonable inference of such intent. All other possible inferences regarding intent were discounted by the FFM as unreasonable. The UN FFM would go on to produce a second report in September 2019, another 419 witness statements. Its conclusion, that the remaining Rohingya lived under a continuing threat of genocide, and Myanmar was failing in its obligation to prevent genocide, to investigate genocide, and to enact effective legislation criminalising and punishing genocide. In the meantime, the United Nations Human Rights Council adopted Resolution 39.2 to establish an independent investigative mechanism for Myanmar, the IIMM. And this would gather evidence of the most serious international crimes and violations of international law committed in that country since 2011. It's gone on to collect still more witness evidence, some of which is before the court. In January 2019, the UN General Assembly adopted Resolution 73264. It expressed grave concern at the findings of the FFM, and I quote, that there is sufficient information to warrant investigation and prosecution so that a competent court may determine liability for genocide in relation to the situation in Rakhine State. These resolutions and their fruits and the work of the IIMM are what in turn catalysed the Gambia into bringing this case to a competent court. And that court is you, offering you the duty and the responsibility to assess and take forward what has been done by a raft of UN bodies, the General Assembly, the Human Rights Council, the fact-finding mission, the IIMM. The Gambia has relied on the work of the United Nations to bring this case to the principal judicial organ of the United Nations. And after the Gambia brought the case to this court, the UN Human Rights Council acted again. By Resolution 4326, it welcomed this court's provisional measures order and called for the IIMM to cooperate in a close and timely way with this court. And the IIMM has so cooperated. It has provided 42 witness statements to the parties, 31 of which are formally submitted in these proceedings. And the head of the IIMM, a lawyer with first-hand experience in the work and prosecutions of international criminal tribunals, he knows what he's talking about, has submitted an affidavit to this court. Why do I refer back to this history? Because it is relevant to the role of the court and to your role as judges. The preamble to the 1948 Convention called for international cooperation to liberate the world from the odious scourge of genocide. And this case is a consequence of that cooperation. This court is at the end of a pipeline that connects the parties to the 1948 Convention with the UN General Assembly and the Human Rights Council, as well as the FFM and the IIMM. And finally, we arrive at the court. In the case of the Rohingya, the court may not have an ICTY to turn to, but it has evidence collected by UN processes established as part and parcel of a deep and long-standing United Nations effort at accountability, one that was directly sanctioned by the General Assembly. So, is this court going to say that the UN has given you nothing, or that what it has given you is somehow inadequate? No. You have a massive evidence, and it emanates from UN sources that are independent and authoritative. And that's what gives it a particular weight, which Mr. Reichler is going to come back to in due course, because the court is the UN's principal judicial organ. Myanmar's argument that you should reject that evidence would demolish the system of investigation and accountability set up by the United Nations. And so we adopt the view expressed by the 6 interveners, including France, and Germany, and Canada, Belgium, and Denmark, and the United Kingdom. And I quote, "Reports generated by the United Nations, such as reports produced by the fact-finding missions, commissions of inquiry, and reports that the Secretary-General of the United Nations may prepare for the UN Security Council or General Assembly, can have special importance. Indeed, such reports can be particularly credible because they emanate from a disinterested witness, namely one who is not a party to the proceedings and stands to gain or lose nothing from its outcome. Special importance, particularly credible." Let's hear what Myanmar has to say about that. There's perhaps another aspect that is relevant. In its Provisional Measures Order of 23rd of January 2020, the court did refer to General Assembly Resolution 73264, and it did place reliance on the detailed reports of the UN FFM. In another case before this court, one of the judges addressed the FFM reports and explained how they were relied upon in these proceedings, in this case, how the court, quote, "examines at length and eventually declares plausible the existence of genocidal intent," end of quote. And that judge proceeds to explain how, and I quote, "based on these findings regarding genocidal intent," end of quote. I'm referring there to the findings of the FFM, and I quote, "that the court considered the rights under the Genocide Convention to be plausible." In other words, this court has already determined by a unanimous decision that evidence of genocidal intent in this case has crossed the threshold of plausibility. What remains is whether, now that the court has studied the extensive written pleadings and heard the oral arguments, whether the court is fully convinced that genocide has been committed. Now, what all of this means, in effect, is that this isn't just a case of the Gambia versus Myanmar. It's actually a case of Myanmar versus the United Nations. for the purposes of Myanmar's council last week was to attack all the work done by every single one of these UN bodies. And of course, those council know, they well know, that if this court accepts that work and relies upon it, then they lose. And that is their fear. And that is why they devoted a huge amount of effort to attacking the reliability and authority of the work of the FFM and the IIMM, which will no doubt continue in the second round. In dulcet tones and in Dickensian style, they seek to persuade you item by item, grain by grain, that the entire UN exercise is premised on a single fundamental flaw. It doesn't meet the standards of international criminal justice. That's what they say. The argument is completely misconceived, as you well know, because this court has been very clear in referring to what it calls the duality of responsibility with criminal tribunals. The ICJ has no criminal jurisdictions, one of the judges on the court has rightly noted. It is, to use his words, a judicial organ for the adjudication of interstate disputes, and it fulfills a role in the field of state responsibility for genocide. State responsibility, not criminal justice, over which international criminal tribunals have no jurisdiction. As the principal judicial organ of the United Nations, this court contributes in its respective field, the judge notes, to a common objective shared with the criminal tribunals, namely the objective of international justice. And it does so on the basis of its own methods and approaches. As the court put it in the Pulp Mills case I know well, mindful of what it called the volume and complexity of the factual information submitted to it, the court will make its own determination of the facts on the basis of the evidence presented to it, and then it will apply the relevant rules of international law to those facts which it has found to have existed. So the court has a well-established practice on evidence. I have lived through it, with it, for 35 years. It will prefer contemporaneous evidence from persons with direct knowledge, and it will give weight to evidence that has not, even before a litigation, been challenged by impartial persons for the correctness of what it contains. Mr. President, members of the court, that describes the FFM reports. They are not specially prepared. They do not emanate from a single source. They are contemporaneous, from persons with direct knowledge, and they are unchallenged by impartial persons for their correctness. Myanmar is alone. Only Myanmar in the world challenges the findings of the FFM and the IIMM. Myanmar is alone in arguing that the witness statements are untested by cross-examination. None of the interveners supported that argument, and Myanmar has not found a single state that is willing to intervene in support to its version of what should be done. None, not one. Mr. President, I've lived through the cases that deal with the use of force, environmental harms, human rights violations, and so much more. And never before have I heard it said that in order to place reliance on evidence, it has to be tested in that way. And so all of this does come back to the history of the 1948 Convention, which entrusted to each of you as judges a role as guardians of the Convention. And it falls to you as the judges, not to some international criminal tribunal that has not yet been established and will never be established, to ensure that the Convention's obligations not to commit genocide are fully respected. That is your role. I turn to the question of the burden and standard of proof. As regards the burden of proof, there really isn't much of a difference between the parties. The Gambia has the burden of proving the facts to establish breaches of the Convention by Myanmar. We have to prove that the Rohingya are a group, and we've done so. In fact, Mr. Staker has stated that, and it's quote, "It is accepted that acts aimed at the destruction of the Rohingya population in northern Rakhine State as such would fall within the scope of the Convention, irrespective of whether that population is a part of a protected group or a protected group in its own right." Next, we have to prove that one or more of the acts set out in Articles 2A to D of the Convention have occurred, and we have proved that. The facts described in our witnesses' testimony basically unchallenged. So that's surely not in dispute, as Ms. Jones will tell you in due course. Next, we have to prove that those acts are connected to an intention on the part of Myanmar to destroy the Rohingya group in whole or in part. And we say we've done that, and we're going to return to this important point. What does Myanmar say in response? They say, well, the Gambia has sought to shift the burden of proof. We have done nothing of the sort. Nor have we sought to argue, as their counsel claims improbably, for some sort of a presumption in favour of genocide. No. What we have done is note that in the face of the FFM reports and the mountains of evidence in support of the proposition that Myanmar intended to destroy the Rohingya group, Myanmar has sought to persuade the court that its actions were motivated by other intentions or motives. The only other motive it has put forward is that it was acting in exercise of counterinsurgency. Professor Talmon told you that if that intention was established, then the intention to destroy could not be established as the only reasonable intention. But he was contradicted by his own colleague, by Mr. Staker, who said to you, and I quote, these are important words, very important words, "Myanmar also accepts that genocide can be committed during a counter-terrorism or counter-insurgency operation." End of quote. Professor Talmon is wrong. Mr. Staker is right. Myanmar can simultaneously be engaged in a counterinsurgency operation against the Rohingya, as Professor Newton told you it was, and also have the intention to destroy the Rohingya group in whole or in part, as Professor Newton told you it did. The mere fact that Myanmar was engaged in counterinsurgency does not prevent the evidence from pointing to an intention to destroy as the only reasonable inference from the conduct. So what other intentions or motives has Myanmar sought to persuade you of? None. We haven't found any. It has not argued that it intended forcibly to remove the population. It has not argued that it intended to engage in ethnic cleansing. All it has argued is that it was engaged in counterinsurgency. And its counsel, on behalf of Myanmar,